Good evening, everyone. Thank you all so much for your patience as we were vamping up. It has been an extremely long day in Newport news for myself, my staff, Attorney Bates, Attorney Case, and Attorney Roughton. So thank you all for joining us for this series of conversations with the clerk. In honor of National Make a Will Month, we heard you all loud and clear, and you wanted more information on how to get started, what resources are available to you, and basically, why is this important? And so today, I am joined with local experts, Attorney Taquan Cates and Attorney Julianne Rowland. And can you all briefly introduce yourselves and let the audience know something about you?
I'll let you go first, Julianne.
All right, sounds good. Well, my name is Julianne Rowland. I am an attorney with my office in the city center area of Newport News. I practice in the areas of estate planning, adult guardianship, and real estate law. I've been in Virginia now for about 16 years. I am a transplant from Vermont, but definitely enjoy the weather down here a whole lot more. And so I look forward to speaking with everybody today.
Good evening, everyone. It's a pleasure to be here. My name is Taquan Cates. I'm the managing attorney for the Legal Aid Society of Eastern Virginia. I practice estate planning, special education, disability, landlord, tenant, family law. So pretty much you name it, I pretty much cover, with the exception of criminal law, of course. I've been here all my life, well, in Virginia all my life. I'm originally from Dinwiddie, Virginia. And I've been practicing in the Hampton Roads area ever since I passed the bar in 2019. It's a pleasure to be here, and I look forward to speaking to everyone and giving everybody, along with Ms. Julianne Rowland, this information.
Well, thank you both so much for joining us again today. And so for the sake of time, we are going to questions. We will be answering questions towards the end of the presentation. We want to make sure to cover as much information as we can because we know that this is extremely important. Also, if you would like the recorded video of this, please in the question and answer box or in the conversations box, you can also type in your email address. That will come directly to us. So the full box of conversations, then make sure you hit host and panelists for answers that will come directly to us. So please include your email address and we will ensure that you receive a recorded presentation from tonight. And then also we will keep you updated on other opportunities that all of us will be hosting. So without further ado, can you all tell us exactly what a will is and why is it important that somebody should have this?
Sure. So I'll give the full legal answer, and then I will give the real human life answer. So a will is determined or is stated to be a declaration of a person's wishes regarding the disposal of his or her property after his or her death. In layman's terms, it's a document that directs a person, normally an executor or fiduciary, as to how another person, so the decedent, wants their estate managed and administered, and who they want to get what specific items of their belongings. It's extremely important across the board, namely because without one, you are going through what are called the laws of intestate succession. So there is a statutory basis as to who gets what. And so if you want to make sure that a specific person gets a specific item, then you need to state that in writing and make sure that it's very clear to the people so that you're not leaving it to chance of somebody thinking that they overheard what you said and saying, oh, little Susie gets this particular item.
Right. Listen,
I'm sorry, go ahead.
Go ahead.
Yeah, so like I agree with Ms. Rowland. This document is extremely important because I'm sure all of us on this call can give you the horror stories of someone dying or a loved one dying without the will, and then their family all in disarray about what property goes to who and what happens to, you know, the house, the car, things of that sort. These documents, well, the will itself is such a vital part of everyone's life. And then once they die, it gives peace of mind for someone to make sure that their property is distributed accordingly. Hopefully there aren't any fights, and if there are fights, they can fight with the document, but not fight with each other.
Absolutely. And so basically what our attorneys are telling you is that it's extremely important. Namely, we don't want families fussing and fighting, and also you do not want the clerk and or judge to have to decide who will inherit things that you worked hard for. Because basically what will happen if you do not have a will in place is that we must administer whatever you have pursuant to the laws of Virginia, right? And so let's say you didn't want this particular person to get your things, or you wanted them to get half and someone else to get another half. That's the importance of a will. Now, Julianne, you said something about intestate. Can you share with the audience, both of you all, the difference from intestate and testate and what that means?
Sure. So the laws of intestate succession. So intestate means dying without a will. Testate means you died with a will. And so the laws of intestate succession is a hierarchy of who inherits property if somebody passes away without a will. And it's all based off of code. The Virginia legislatures are very nice in providing us with a complete roadmap as to if this person, then this person, then this person. And so that is intestate. Testate is dying with a will. So the will is otherwise directing who you want to receive what items and in what proportion.
Right. Now, Taekwon, I heard you both speak a little bit about property. What if someone doesn't own property? Do you think they should still have a will? Can you share with us a little bit about what types of things may be included in the will?
Sure. So I most certainly always advise clients, even if you have just a little bit, let's say $100 that is in the bank account, get a will done. I think it's such a vital document to help, again, the testator or the person having the will drafted to distribute the property accordingly. Some things that can be distributed in property or in a will, which are called probate assets, are things like a house, things like a car, things like jewelry, clothing, things of that sort. Those are the things that can be distributed. And also there could be a issue where someone dies, and let's say that they do have $200 in the bank account, but then somehow, somewhere or another, someone finds out that this particular testator had $1 million stashed somewhere that they didn't know about. And now who's going to get that $1 million? How is the court going to determine who's going to get that $1 million? So those are some of the things that the will can address. And if it is addressed in the will, then the appropriate people, the appropriate beneficiaries are able to get those things.
Right. So I heard you say beneficiaries. And one of the questions that we get asked all the time, people come into the courthouse and they're saying, hey, well, I'm on the life insurance policy. Why am I not getting the car? I'm on the life insurance policy. Why am I not getting access to the bank accounts? So can you talk a little bit about beneficiaries and the difference from having a will versus your name being listed in let's say, life insurance policy?
You want me to take it?
Oh, go ahead.
No, you got it.
So the big thing is assets that pass outside of probate and assets that pass in probate. Beneficiaries frequently are listed on specific, there's two different ways. There's two different documents. If it passes outside of probate, it passes by virtue of either a transfer on death, a pay on death, or a beneficiary designation on a specific item. So bank account, life insurance policies, real estate can actually be transferred by a transfer on death deed. So those things all pass outside of the will. The will, if it identifies the beneficiary is identified in a will otherwise inherit by virtue of that document.
Absolutely. And I want to give a quick shout out to Delegate Marcia Price, who also hosted a estate planning workshop earlier this week in honor of National Make a Will Month. So she gave me a call earlier today and she said, let's for on death deed. So can you please make sure you cover it? And so thank you so much for bringing that up. Can one of you kind of touch a little bit about a transfer on death deed and what that entails and what happens should you pass away, but you had the transfer on death deed? What does that look like?
Well, I think I'll take this one. So transfer on death deeds are documents that get done during a person's lifetime. It is a will or deed that gets recorded in the land records prior to the person passing. And as a matter of law, it otherwise passes to the individual, presuming that the person has not conveyed the property out, whether by sale or by revoking the transfer on death deed, and they still own the property when they otherwise pass away. At that point, the property passes to whoever the named beneficiaries are in the transfer on death deed itself. One of the caveats with transfer on death deed, so they're a relatively new document. They only came out in, I think it was 2013. One of the caveats on them is the person who inherits or who is the beneficiary under that has to survive the person conveying the property. And so it's not a tool necessarily that you can otherwise have succession in decedents or, you know, subsequent beneficiaries of one person. But it's a document that gets recorded in the land records, just like every other deed, and presuming that the person still owns the property when they pass away, it goes down to the beneficiary that's beneficiary or beneficiaries who are listed in the document.
Right. And so guys, transfer on death deeds are recorded in the circuit court. The circuit court in Newport News is located at 2500 Washington Avenue. And as Attorney Roughton just stated, this is something that we've done prior to you passing away. It will be listed, in the deed. And so should you pass away and the person that you listed is still alive, they do not have to come down to the clerk's office to re-record another deed. What would happen in the city of Newport News is that they would visit our city assessor's office with the death certificate, letting them know that the person has passed away. And then the city assessor's office would then transfer the property into that person's name. That deed that was already completed is now your deed. Now, should you want to change something else, that's your right to do so, but legally you don't have to. And before we continue to go with the presentation, because I know we have a lot of questions that are coming through the chat box, just wanted to iterate, if you have any personal questions as it relates to your matter, we ask that you please hold on to those, and please, please, please seek an attorney that's licensed to practice law in the state of Virginia. The information that we will be presenting tonight is not legal advice, but it's strictly guidance pursuant to the laws of Virginia. So again, if it is your personal matter that you're inquiring about, please seek an attorney that's licensed to practice law in the state of Virginia. If you have a general question, ask away. We are happy to assist with general questions and provide information pursuant to the codes of Virginia. So we're gonna keep it rolling. So do you have to be a certain age to create a will?
You want it to be at least 18 years or older in order to have it executed or properly executed.
Okay. Now, if you have a will, once you're 18 years or older, are you able to list minors in that will?
For 18-year-olds, it becomes more complicated. If you want to add minors to a document, I mean, it could be issues where the 18-year-old may have a minor child that property can be inherited, but that's a whole separate area that is complex. Like I said, you have to appoint a guardian for the minor in the actual will and things of that sort, which it can be effectuated in the will, but that becomes more complex. But an 18-year-old technically can appoint a guardian for the minor, depending on what property that is needed to be allotted to the beneficiary.
Okay, gotcha. So let me ask you this. We spoke a little bit about an executor. I heard that word used a little bit earlier. Can you all explain to the audience what an executor is?
Sure. So the executor, that's the individual who has been tasked or appointed to distribute the property upon the testator. That person I would like to pretty much say, and pretty much have a huge disclaimer, make sure that the executor is someone that you trust, someone that you know is going to distribute the property accordingly, that they won't do anything that you do not want or know your wishes to be done. That executor is responsible for making sure that whatever wishes that are listed in the testator's will is divvied out appropriately. And there are consequences if the executor doesn't do that, but it's important to note that that executor needs to be someone that you trust, and you should take some time in appointing who that executor may be. Even if it's your best friend, it doesn't have to be your best friend. It could be a sibling, it could be a family member, but you need to make sure that that executor is going to be someone who actually do what you want to do in your will or what have you. But another key point is, if you are appointing this person as your executor, make sure that the executor know, because this is a task that shouldn't be taken lightly. Executor is a very important role in the actual will. That person is, again, responsible for making sure that the will or the wishes of the testator are divvied out and done appropriately. And so that is a lot on the executor. That's a lot on a person, and that person has to be willing and capable of doing those things. And I also will mention that even with an executor, it's also advisable to have like an alternate executor just in case life changes happen or circumstances happen where that executor is no longer living or become incapacitated or whatever the reason may be. Have like an alternate listed in there such that, you know, the wishes are still carried out by the testator.
Absolutely. So can we touch on a little bit? I have kind of like a two-part question. So we'll start with the first part. Can you all talk a little bit about how to get started with a will, and roughly the cost, and if there's any resources available?
So a couple of the big key questions that I always recommend that people consider when they're talking about a will is to get an idea of, number one, what is your estate consist of? So generally there's going to be a couple of different categories that estate assets will fall into. The first one is something that's called colloquially tangible personal property. That is a really fancy phrase for all of your stuff. And that's going to be vehicles, that's going to be family jewelry, that's also going to be family pets, which is hard for some people to hear that it's a stuff item. So knowing who you want to get those specific items, if there are specific things you really want to go to somebody, having that listed out is very helpful. Kind of getting an idea of what the nature of your estate is. Are we talking bank accounts? Are we talking real estate? Are we talking antique collectibles? All of those things are kind of fact gathering things that individuals should start looking at and figuring out how do we want this divvied out, or who do we want this divvied out to? Right. And then figuring out who your beneficiaries are going to be. So who you want to inherit from you. And then I would absolutely piggyback off of what Taekwon stated, who your executor is going to be, because the executor carries the full burden of all of this. They're the ones who are going to be making sure that they follow the letter of the law of the will to the absolute best possible terms. And so getting that conversation going, it's not a conversation anybody likes talking about. It's not a Thanksgiving dinner table conversation, but it's things that make it a lot easier for a loved one, knowing that these documents are in place and that they're appropriately done. Because unfortunately, a lot of times when people come to see attorneys, it's because mom or dad didn't have these documents. And now they're going through the nightmare of trying to navigate through that without any documents to help them through it.
So can we talk a little bit about that? Let's say mom and dad didn't have a will in place, and someone has to go through probate. Can we talk a little bit about probate and what that process looks like, and ways potentially that people can avoid going through probate and paying that either state, federal, or local tax?
I'll let you handle that one.
Sure. So probate, honestly, we could do an entire seminar just on the probate process. Probate is, if you otherwise have a will, it's the act of offering the will to the clerk of court, or to the court itself if it's not meeting certain statutory requirements, and following through with the desires in the will. If a will does not exist and the person's going through the laws of intestacy, then at that point it is essentially administering a person's estate. Same general concepts: tangible personal property, real estate, cash or cash equivalents, etc. One of the easiest ways to avoid probate is to have your ducks in a row, whether that be with beneficiary designations, transfer on death designations, pay on death designations. All of those things are very, very great tools that are available in the right situations, and not all situations lend themselves to that. If you have minor children, please don't give them real estate. That is an absolute nightmare for everybody. If you have a special needs child, you may not want to have them inherit stuff personally. You may need to have a special needs trust. And so all of those things are things that you are tasked with to make sure that your loved ones are doing and are able to accomplish your wills and desires in the least possible chaos as possible. The probate process is going to depend on the jurisdiction that the person passes. So probating is going to be done in the jurisdiction or in the city or county that the person resided at the time of passing. So that is the residency. And so you can do multi-jurisdictional probating sometimes. And so that's always an interesting thing if you have real estate in different jurisdictions. So you have a piece of real estate in York County, but the person dies a resident of Newport News and has a house in Newport News. You may have to do something that's called ancillary probating. And the easiest way to avoid that is by having everything in place to be able to make sure, either by virtue of trust, by virtue of beneficiaries, pay on death designations. All of those things are various tools that can be used in a toolbox to accomplish a person's necessary outcomes.
And I want to piggyback off Ms. Roughton said, in particular, the disabilities. So if you have someone, let's say a disabled child who is receiving SSI benefits or Social Security benefits, it's important to understand what that is and understand, like, when you're thinking about your estate and what you want to do with your estate, it's important to understand that that could affect that individual, if it's a disabled person, how much they can get or what they can receive. And that's the reason why special needs trusts need to be taken into consideration and should not be taken lightly. Because if you were to, let's say, and if you were to, testator were to give $1 million to a person with a disability who is on a fixed income, SSI has a income cap, it's $2,000. So anything over $2,000, once Social Security sees that, they're going to cut off the benefits. Same thing with Medicaid, they're going to cut off the benefits. So it's important that the special needs trust is set up such that that person is still able to live their life and also not be hindered by the amount of inheritance that is coming in for that particular person. So it's important that if you have a family member who you want to give some type of inheritance to, that you create some special needs trust such that that can be happened, so that can happen.
Absolutely. And Ms. Roughton, I do want to thank you also for pointing out that probate may be handled differently depending on your jurisdiction. You can go to Newport News, York County, Williamsburg, Hampton, 4 different clerks, several different judges, and we're going to handle those things several different ways. And so with that being said, I do see that my staff is on. So I want to thank my Chief Deputy Stacy White, who is on, and I also see my Assistant Chief, Ms. Bernadette Price, who actually manages probate in our office. And so if one of you ladies could please, in the chat box for the general public that they can see, if you all can drop the link to our probate portal into our frequently asked questions. All right, and through the duration of this presentation, I have several staff members that are on. So thank you all for joining us. I know it was an extremely long day. We just finished a jury trial, guys, at almost 6 p.m. tonight. So thank you all for, after a long day, being on, and for your commitment to the citizens of Newport News and to the Commonwealth. I know I tell y'all all the time, but I like to publicly say it also, that I appreciate what you do, and I would not be able to do what I do without each and every one of you. So I thank you all for being on tonight, and thank you for the work that you do each and every day. Throughout the conversation, they will be dropping information in the chat box for you all. Again, we are recording this, and so anything that you want to go back, rewind, if you drop us your email address, we will send this video to you once we have downloaded it. With that being said, I'm going to kick this to you, Taquan. Can you talk a little bit about when someone should consider creating a will? Is it a right time?
So it's, in my opinion, I think that there is times where it's best to actually create the will, but technically speaking, when you turn the age of 18, you need to start thinking about, what you want to do with your property upon, your death. Now, most 18-year-olds are not thinking about that at all. They're thinking about the next college that they're trying to go to, or whatever the case may be. But technically speaking, that's when you want to start like thinking about those type of things. But from an adult standpoint, once you start having children, that's a good time to start thinking about or planning about, all right, what I want to do with my property, how much, money I'm going to give to my children, or if some type of illness come into effect. That's probably another time where you need to start having those conversations with family members. I know it's a hard conversation, but it's a conversation that needs to have in regards to what you want to do with your property. Another time that you want to probably have this conversation is when it's when you get married. That's another time where you want to make sure that everything and all your ducks are in a row in regards to your will. That's another time that you can do that. And also, I would like to add that it doesn't matter whether you have a $10 million bank account or whether you have a $100 bank account. It's important that you make sure you iron out everything that you have. It doesn't matter how much you have or how little you have. It's important to actually have this will, and creating the will is absolutely something that you need to do.
And Taquan, I'm glad that you spoke about having these tough conversations. I know for many people it is extremely difficult. Some people feel like it's a be all to end all. But one thing that I will share with you all, and that I see each and every day, is that someone passes away and the family members, they just aren't aware if there was a will or not, or they know there was a will, but they have no idea where it's located. And I would encourage you too, once you've executed this will and you have it, make sure you have someone that you trust where they know where the original will lives also, because when you come to the clerk's office, and this is standard across the board, no matter what court you visit, you have to have the original will. It cannot be a copy. And so make sure you have the original will. Make sure your loved ones know where your will is located. Now, in the state of Virginia, if you put your will in the deposit box, that is one of the few times where upon death, your family member can access the deposit box just to locate the will. That's it. And so just wanted to make sure that you all were aware of that. Now, question for both of you all. Can you touch a little bit on common misconceptions that you've heard as it relates to wills and estates, or things that people, like, they're just common saying, and it's like, where did that come from?
So I will say one of my favorite ones that I get is, I got my will online. That is absolutely my favorite thing. I will say I did not get my law degree from Google. And so in this regard, there is a reason why there are professionals out there. Wills state your desires and your want upon your passing. So if something is misconstrued or not understood, or if there's inaccuracies, unfortunately, most of the time that is found out is when the person who created it is no longer with us to ask those questions. And so it makes it very challenging. And a lot of times in those situations, a person will have Googled it and pulled a form online. And for some reason, they all seem to be based out of California law, which California is very, very different than Virginia. And so it's hard to have those documents be symbiotic. And
Absolutely.
The problem that we see a lot of times happen is when these documents are drafted and they're not done properly, that's when the attorneys get involved. And at that point, you're talking litigation attorneys. You're not talking transactional attorneys that are, in my general experience, a much cheaper grouping of attorneys than litigation attorneys are. And so it's challenging because at that point, your loved ones are going through the grief process, but they're also then trying to figure out, okay, well, what do we need to do to be able to accomplish this? And so that is one of the biggest misconceptions that I hear is, well, I got this off of Google. I got this from, my great aunt Susie who had one done. Wills, although they are generalized, most estate planning attorneys will sit down and speak with the clients and say, what do you need? What does your specific situation entail? So it's not a, one size fits all situation. And so that is, I would say, my biggest misconception that I hear all the time is, I've got something because I got it off of, Google or Bing or whoever the service provider is. And they think that it's accomplishing what they want it to, but in the long run, it becomes more troublesome for them.
And you pointed on something that was so good, both of you all, when you were speaking earlier about Social Security and if you inherit a certain amount, how that could default on your benefits. You spoke a little bit about, special needs children. That's what I would say. These are the important things about consulting an attorney, because it may be things that you need, but you just didn't think about or you didn't know exist. And so even though I see cases like this every single day, as I'm sitting here listening to Attorney Cates and Attorney Roughton, I'm learning right here with the audience, and I'm like, oh my gosh, that is good. I didn't think of that. And so that is the importance of consulting with an attorney. And you pointed out a great thing about, California different, every state differs. And so you will hear throughout this presentation, and as all three of us are talking, you keep hearing us saying the Code of Virginia, the laws of Virginia. And we are strategic in saying that because every single state is different. All right. So with that being said, can we talk a little bit about the difference between a simple will and a living will?
So living will, it's commonly, I think could be considered in misconception, as well as a living will is an advanced medical directive. Essentially, it deals with someone handling your medical needs or making decisions on your medical behalf if you become incapacitated for whatever reason or things of that sort, or if you don't want to be resuscitated. That's what a living will is essentially another name for an advanced medical directive. But a simple will is what Ms. Roughton stated earlier. It's a legal document that distributes property upon someone's death. So that's a huge misconception.
So when you go to the hospital, for those of us that have been, and we have someone that's extremely ill, and sometimes you'll have the social worker come in or whomever, and they say, here's this advanced directive, or here's this living will. What are your thoughts on that? Should someone consult an attorney? Do you think that's something that we should be looking at? What are your thoughts?
So I will say the two documents that I think that every person should have starting at 18, regardless of what an estate otherwise looks like, in addition to a will, are power of attorney and advanced medical directive. Those are the two biggest documents that I will say, even from my side as an adult guardian attorney, is people don't get them done, and that's actually helping you while you're alive. So financial power of attorney has kind of a known name. It's naming somebody who you want to be able to help you handle your finances. And they can either be effective immediately or upon an incapacity. An advanced medical directive is a huge document because none of us know what tomorrow brings. We could be in a catastrophic car accident and be rushed to the hospital and not be able to make decisions. And so having that directive states a couple of things. Number one, what your wants and desires are as it relates to life prolonging procedures, things along those lines. But it also states just your overall wishes, because these are very uncommon conversations to have. Nobody talks about, well, if this, then that. And so the advanced medical directives are a huge benefit, and they can be tailored to make sure that you are, your desires and your wants are being adhered to. And you're also naming who you want to be able to make those hard decisions, and giving that person or that loved one direction so that they're not just pulling it out and hoping that this is what you otherwise wanted done. I would always say it's beneficial to have an attorney and speak to an attorney if you are in a position to speak to an attorney about those documents. But I also understand in certain emergency situations, you may not have the time available to be able to go speak to an attorney. And if they're otherwise being presented at a hospital, again, depending upon the capacity level, at least there's something in place, because those are really challenging times for loved ones. Not only are they dealing with the emotion of whatever is happening, from a medical perspective, but then the unknown of, well, I don't know if mom wanted to, be resuscitated, or I don't know if dad wanted to go to hospice. And so by having those documents in place during your lifetime before they're ever needed, it's a lot easier, not only for you, knowing that your wants and desires are going to be adhered to, but also for the person who is tasked and charged with following through on those. Because otherwise, if there aren't documents in place and you become incapacitated, then the courts get involved, and the judge is ultimately the one who is appointing somebody to act on your behalf.
Yes.
Again, piggyback on what Julian said, is just like a will, the fights that happen or bickering amongst family, same with the power of attorney, same with the advanced medical directive, you prevent these conversations from happening, you prevent these things from blowing up as if they, were something that wasn't supposed to. It's important to have these 3 documents. We cannot stress that enough. If you take anything away from this webinar, is to make sure that you sit down with your loved ones, or you sit down, by yourself, and have that conversation. Just, think about your life, think about what's going on, think about what you need, and then start planning it. Consult an attorney to see what you can do to get these documents in place in the event that something unfortunate happens. It's important. It's not a bad document to have. It's just, look at it as security. It's security for, your life, but also beyond life. It's security for everyone. It brings peace to everyone. So we cannot stress it enough. These 3 documents are important.
Right. So question for you both. If you have a will, or as you're preparing your will rather, can you include people that may not be United States citizens? Are they able to inherit?
So the answer is yes, but there are going to be a lot of other things that have to be taken in consideration depending upon who you're otherwise leaving things to, and not only from a inheritance side, but also from a tax side. And I will say, I am not a tax attorney, and so I always have my estate consultation stating that you need to have your CPA in the conversation as much as your attorney involved in the conversation.
All right. So what are your thoughts on married couples having a will? Under Virginia law, do assets automatically go to a spouse?
So I think it will, for starters, from like a personal standpoint in regards to like the legal side, it's not bad for both the husband and the wife, or however you see fit, to have a will. Like the partners can have a will. That's completely fine. Both of them can. The problem will happen if you don't have a will, is what Ms. Julian said earlier, is about intestate succession. Because if you, let's say there was a married couple, but they die without a will, but let's say the husband had a child that is not biologically the mother's, the thought process is, oh, well, all the money will just go to the wife. That's fine. All the property go to wife. That's fine. That's not the case. Intestate succession won't allow that. There's the Code of Virginia will definitely tell you where that goes, who gets what property, and how much property goes to whoever. So that is important to also understand. So it's no problem with both partners getting a will. Just make sure it's ironed out such that the wishes are conveyed appropriately.
Absolutely. Absolutely. So Taquan, from your work with the Disability Rights Unit, what unique estate planning considerations exist for individuals with disabilities or families with disabled members?
Yeah, so we touched on it a little bit earlier. So when like disabilities, individuals or families with disabilities, when they're drafting the will, to make sure that there's a special needs trust drafted up in the will to make sure you take care of that family member. Is what Julian was talking about, transfer of death deeds, these different tools to help this disabled person benefits not get stopped or life be altered because they're receiving an inheritance from their loved one. So those are the things that are tools that a person can use to help effectuate what they want and not hurt the beneficiary.
Right. So I'm receiving a question, and while we are talking about spouses, I did want to take a minute to touch on this a little bit. Either one of you, can you share with the audience if Virginia has what you call common law marriages for individuals that may have been together for a long period of time, but they are not legally married pursuant to the laws of Virginia?
In the Commonwealth, there's no common law marriage. You have to have a marriage contract. You have to go through the court and then have a wedding and things of that sort. Like that is the process that you have. You have to actually get married. The Commonwealth does not recognize common law marriage, which again, going back to the plug, make sure you have a will, because that can create a lot of issues that may not be necessary if things were ironed out appropriately. But no, the Commonwealth does not recognize common law marriage.
Okay, and can one of you touch a little bit about what divorce means versus separated? Because we get this a lot in the court, and people will come in and say, well, they weren't married, but we don't see a final divorce decree. So if we touch a little bit about that, when is someone legally not considered a spouse?
Okay, so when it comes to divorce, so you have to have the divorce decree. Once you go through the entirety of the court process, the filing of the complaint, and then the answering of the complaint, and then you have a hearing on the divorce, and then the judge signs off on the actual decree, that's when you're considered divorced.
Okay, I'll cut you off right there. We just gonna pause for 1 second.
Okay.
The judge to sign it. The final decree has to be signed by a judge. Okay, go ahead.
Yeah, it has to be signed by the judge to make sure that both parties are now officially divorced. Now there are such thing as separation, and there are separation of agreements, and those things are legally binding depending on what is contained in that particular document. Some things may be ironed out already, some things may not be. It just depends on severity of what the case may be, and sometimes that can be drawn out, however the case may be. But from a legal standpoint, Virginia, you have to be divorced. And that means if you're not divorced, then that other spouse if you die without a will, can inherit some property, even if it's a tumultuous marriage.
All right, so the time is now 6:51. We are going to begin to take questions from the audience. One of the questions that we received was, can you touch a little bit about the average cost to create a will, and if there are any resources available to help offset that cost?
So I will say in the private practice area, wills and estate plans are going to be varied. It's going to be varied based on what your actual needs and what the documents are that are actually going to be provided. I would say you're probably looking into the hundreds to thousands, depending upon what type of estate plan you're looking at. I will let Taquan kick it off as it relates to what services otherwise might be available from a non-private practice standard.
So for our standpoint with legal aid, the estate planning process is totally free for individuals who qualify for our services. So if you fall under 125% of the poverty line, that means that you're eligible to retain services or retain our services. And we draft the will, the power of attorney, or the advanced medical directive free of cost. So all you have to do is we complete our interview, we create our process, and then we either come to you if you're in a state where, well, not state, but like if you're in a condition where you're unable to come to the office, we'll come to you to make sure that we effectuate the will. We'll bring our own witnesses, we'll bring our own notary as well. In addition to that, we can also have a will signing or estate signing at our offices. So those resources are all available to individuals who qualify for our service, and it's free of cost.
Okay. And how would a person find that information?
So we have our website. You can visit our website, Legal Aid Society of Eastern Virginia, or www.lacebo.org, or you can call our central intake unit. They are open from 9 to 1. And you also can come to 4 of our offices. So we have an office in Norfolk, Virginia. We have an office in Hampton. We have an office in Williamsburg, and we have an office on the Eastern Shore. So all 4 of our offices are open to the public. So you can most certainly come to our location. We may certainly take care of that for you.
And Julianne, can you also let the general public know how they would be able to get in contact with you also?
Sure. So most private practice attorneys have websites, so most of them you can just Google. Our website is www.routenlasterlaw.com. That's ROUTTENLASTERLAW.com. But most of the time, if you otherwise Google estate planning attorneys or specific names of attorneys, you can find them on Google, or lawyers.com is also another good resource that a lot of times people are able to use to find attorneys that practice in this area as well. And I do know with our military, our heavy military presence here, a lot of JAG offices will offer estate planning documents to some extent for their military associated individuals as well.
That's awesome. That's amazing. So Taquan, correct me if I'm wrong, but legal aid is also a nonprofit, a 501(c)(3). Is that correct?
Yes, we are a nonprofit organization.
Okay, so with that being said, guys, to keep nonprofits going, we know that it also takes finances. And so if you are the type of individual that's so into nonprofits, make sure that you consider legal aid, because in order for the services to continue, then of course they would need funding. I am happy to say legal aid is one of the societies that I do support, because they bring forth valuable information just like this to our general public. And so again, legal aid is a nonprofit, a 501(c)(3) if you are interested in contributing to that organization. And I am going to see if we have any other questions. Okay, someone wants to know, is a self-typed will valid if notarized?
I'm sorry, I didn't hear the full question.
Is a self-typed will valid if it is notarized?
If it's also witnessed, possibly.
Okay. Now,
So,
does the will have to be filed with the clerk of court? So in Virginia, we do not record wills until the person has passed away. But yes, once the person has passed away, if you come to the office, then yes, we do record the will. That is pretty much the probate process, a big part of it. Again, I want to reiterate that it must be the original will. It cannot be a copy of a will. Someone else has a question about handwritten wills. If you are able to handwrite wills.
So you absolutely can, as long as it is wholly in your handwriting. So it is not typed part of it, handwrite part of it, anything along those lines. It has to be wholly in your handwriting. And again, it also has to be signed and witnessed by two witnesses as well. And so there is definitely a process to be done. And with that, I will also add a caveat of once a will is properly executed, any modifications or alterations should be done with extreme caution, because a lot of times individuals will strike through somebody's name thinking that they can just date and initial it. And in certain circumstances, if it's not done properly, it could invalidate documents. And so it is not just simply, we're going to change something or add a page, ledger notebook of some sort. Everything needs to be done according to the statute to be able to make sure that it stays in compliance with Virginia law. And so again, this is one of those, it's very, very, very advisable to make sure that you are speaking to an attorney when you're making modifications so that you're not undoing something that you just spent, time and possibly money doing to avoid issues.
All right. And I have a question for me. The question asks, if a will is recorded, how does a family member find it? So once a will is recorded in our office, that is public record. And so you would just give us a call. We do have terminals inside of the office, so you can visit anytime, Monday through Friday, 8 a.m. to 4:30 p.m. We have public terminals. And so we can show you how to use those to locate the will, or of course, you can give us a call or email us, and any documents that we have, we will provide a copy of whatever is public information, and wills are public information, probate matters are public information. So our email address is ccourt@nnva.gov. Again, that email is ccourt@nnva.gov. And if my team could drop that in the chat box for the general public. And we are located at 2500 Washington Avenue. Phone number is 757-926-8561. Hold on. This is my team is texting me now to say, don't forget to mention the cost. The cost of a copy is 50 cents per page. In order to certify it, it is $2. That's not $2 per page, but $2 for the entire document. All right, let me see what other questions we may have.
And can I add one thing, Ms. Reason?
Absolutely.
One thing I do want to stress is to make sure if you get a will drafted and properly executed, is that you check on your will every 3 to 5 years, just to make sure everything is, what you want, your wishes are going to be carried out as you want. Because again, life changes happen. Excuse me, the light went off. But life things happen. And so I just want to make sure that people are making sure that their will is what they want it to be. Every 3 to 5 years, just look it over and make sure everything is still where it needs to be. And if it's not, contact an attorney, make sure they can get those changes made, re-execute it, and make sure your life is good.
And that was actually the next question. When should a person consider changing their will, or if they should consider changing it? So is there anything else that you would like to add to that, Julianne?
Yeah, so I will actually say, I normally say if one of three things happens, in addition to the timeliness portion, if the nature of your estate changes. So if you go from having a single family house, in Virginia, to buying a vacation house in Vail, Colorado, or you're a millionaire because you won the Powerball. If the nature of your estate changes, that should definitely be a trigger point to make sure that your documents are still doing what they need to do. If your beneficiaries change, so along with the marriage and having kids, if your kids get married, or if you start having grandchildren, or if one of your beneficiaries predeceases you, all of those things could trigger unnecessary or unintended consequences that could easily be avoided. And then if your fiduciaries change, So similarly, so if you have somebody named as an executor or as a trustee, if that person's no longer in a position to serve in that role, whether by death or incapacity, or you've had a falling out, again, that's a good time to kind of update your documents to make sure that things are being done the way that they should be. Because as Taekwon had indicated, having multiple layers are great if you have beneficiaries and contingent beneficiaries and executors and contingent executors. But if something starts happening to those individuals and you don't reevaluate at that point, your contingencies may not act as the safety net you otherwise want.
All right, I'm doing one last browse to make sure that we did not miss any questions that we did not touch on. Nope, I think we're good to go. So prior to, before we wrap up, Attorney Cates, Attorney Roughton, is there anything in closing that you would like the general public to know?
I just thank you for the opportunity to speak to the community about wills. Again, it's such an important thing and very informative, Ms. Roughton, as well. I appreciate speaking with you and us both explaining to everyone about what wills are and how to get one done. It's just, again, important. I've been saying throughout this whole webinar, have that conversation, start planning your life out, make sure that you get everything together, because again, it brings that peace of mind to not only yourself, but your family. And what is the all essence of it is you just want to protect your family. You just want to make sure that everything is set up so when you leave this earth or something were to happen, unfortunately, you don't have nothing to worry about. So you take anything again from this, just make sure that you have that conversation. And I'm here if you ever want to have that conversation. Again, I explain the resources that we have. You can always give Legal Aid a call, and we'll be happy to take care of you.
And I will definitely mimic that. Thank you, Ms. Reason, for inviting us and for having us speak in this, and honestly for offering these kinds of services for our community. I will also go on and say that there are thousands of attorneys in the Commonwealth of Virginia. There's a reason why there are thousands of attorneys, because you want to find an attorney that you feel comfortable with and that is doing what you are hoping to be able to accomplish. And so there is no issues, at least from my personal opinion, to finding an attorney that you feel comfortable with. So it may not be the first person you talk to, but you want to make sure that you feel comfortable when you're leaving that attorney's office with the documents that you have, that they're doing what you otherwise want them to do. Because again, unfortunately, if you have questions, a lot of times if you're the one who has had the documents drafted, you're not going to be there if the questions otherwise arise. And so having that really good relationship is a very key thing, because that's going to help you navigate through some of life's hardest times and allow your family to be able to navigate through that as well.
Absolutely. And before we close, I do have one question that is so good, and I want to make sure we briefly touch on that. The question is, should you or do you have to see the same attorney to make updates to any of your estate planning documents?
No, I wouldn't say that there's any requirement that they have the same attorney draft them. Obviously, attorneys retire, or at least my understanding is that attorneys retire, and so your attorney may not be there if you otherwise need to make updated documents. The big thing is making sure that the attorney, if they're doing modifications to your documents, understand the reasoning for it. Because as Taekwon had indicated, the laws change, tax laws change, everything changes from time to time. And so what may have been a great document 15 years ago may not be the same results that you intend them to be now. And so it's not necessarily you have to have the same attorney drafting them. You just need to make sure the attorney understands what your end desires are so that they can accomplish that.
Absolutely. All right, well, the time is now 7:07. Attorney Cates, Attorney Roughton, I want to thank you both so much for joining me this evening. I would not be able to do this without you both, without your expertise. So thank you for taking out of your long day to help pour into the citizens. It means so much to me. You all are the experts. And so, of course, I respect you both and I respect your profession. I just want to reiterate to the general public that there is no one size fits all. And we have people that visit the clerk's office every day and they ask us, well, what should we do? And we are only able to tell you administratively how we process your documents. You have to tell us what you would like us to do, and we handle it pursuant to the Code of Virginia. And so the advice that we are going to give is the advice time and time again, and that's to seek an attorney that's licensed to practice law in the state of Virginia. And one, yes, because that's the law, but two, because we would never want to tell you something and you don't get the outcome you expect because a non-practicing attorney, because we're administrators, told you something and the law has changed, or it's just not something that's best for you. And so again, this month is National Make a Will Month. I encourage you all to talk to your families, go consult with an attorney that's licensed to practice law in Virginia. Even if you decide that you do not want to utilize their services, at least do a consultation to see what is right for you and what is right for your family, because no one should know you better than you. No one should know what you have better than you. And so I think I can vouch for both attorneys on and for myself and my entire staff when I say we want to ensure that what happens with your matters, the things that you have worked so hard for, no matter how big, how small, how whatever, whoever may think it is, that it works the way that you intended it to work. And that when we all pass away, because we will, that our loved ones also do not have that stress and that pressure of having to figure it out. And so with that being said, happy National Make a Will Month. I have put their information, both Attorney Cates and Attorney Routen's information in the chat box. Reach out to them or whomever you deem necessary, but please do not wait. Make sure you get started tomorrow. Thank you all again for joining me for this session of Conversations with the Clerk. Have a great evening.
Thank you.
Thank you.